Judgment in the appeal in the matter of an application by Martin Corey for judicial review.
Lord Kerr will summarise the judgment of the court.
In 1973, Martin Corey was convicted of the murder of 2 police officers in Northern Ireland. He was sentenced to life imprisonment. In 1992, he was released on licence. 18 years later, on the 15th of April 2010, his licence was revoked after his case had been referred to the Parole Commissioners for Northern Ireland by the Secretary of State. That decision was based in part on confidential information from the security services. Mr. Corey has been in prison since the revocation of his licence. After Mr. Corey's licence was revoked, his case was referred again to the Parole Commissioners, as is required under Article 9, Paragraph 4 of the Life Sentences Northern Ireland Order 2001. The purpose of this second reference was to review the propriety of the revocation of his licence and of Mr. Corey's continued detention. Hearings were conducted before a full panel of commissioners. Parts of those hearings were conducted in closed session. The panel gave its decision in a judgment that was partly open and partly closed. In the open part of the judgment, it stated that it was satisfied that Mr. Corey had become involved in the Continuity Irish Republican Army from early 2005, and that he was in a position of leadership in that organisation from 2008 until his recall to prison. It was concluded that the appellant posed a risk of serious harm to the public at the time of his recall. Mr. Corey challenged the Commissioner's decision. One of the grounds of challenge was that he had not been given sufficient information about the closed material on which the Commissioners had relied. A judge accepted that argument and ordered that the Commissioners should reconsider Mr. Corey's case. He also ordered that Mr. Corey should be released on bail while that reconsideration was taking place. The Secretary of State appealed the judge's decision that Mr. Corey had not been given sufficient information. There was also an appeal against the decision to grant Mr. Corey bail. This second appeal was dealt with first, and the Court of Appeal decided that the judge did not have power to grant bail. Mr. Corey appealed to this court against that decision of the Court of Appeal. But before his appeal could be heard by this court, the Court of Appeal decided the first issue. It concluded that Mr. Corey had indeed been given enough information. It therefore reversed the judge's decision, directing the Parole Commissioners to hear his case again. Mr. Corey was refused permission to appeal against that ruling of the Court of Appeal, and the only matter with which this court was concerned, therefore, was whether the High Court had power to grant bail to Mr. Corey. The Supreme Court unanimously dismisses Mr. Corey's appeal and affirms the Court of Appeal decision that the High Court does not have power to grant bail in these circumstances. Bail should be granted where it is necessary for the effective disposal of a claim and provided it is not contrary to the purpose or spirit of the legislation in question. The judge's order that the review of Mr. Corey's detention had not been conducted lawfully and that it should be reconsidered was, on its own terms, a full vindication of the right which Mr. Corey had asserted. Moreover, to order release in the circumstances of this case would run directly counter to the operation of the 2001 order. One of the principal philosophies underlying that order is expressed in Article 6.4, which provides that the Commissioners shall not direct a prisoner's release unless satisfied that his confinement is no longer necessary to protect the public from serious harm. And Article 3.2 requires that the Commissioners should have expertise from a wide variety of fields. One must hold or have held judicial office, one must be a psychiatrist, one must be a chartered psychologist, one must have experience of working with victims of crime, and one must have expertise in the causes of delinquency or the treatment of offenders. This requirement reflects the need to have available a range of specialists who can contribute to what must often be a difficult debate as to whether the rigorous test set out in Article 6.4 is satisfied. Put simply, the legislature has placed in the hands of a panel of experts the difficult decision as to when a life sentence prisoner should be released. Their role should not be supplanted by a judge who does not have access to the range of information and skills available to the Commissioners. The recent judgment of the European Court of Human Rights in James against the United Kingdom was considered. It appeared to suggest that if a prisoner has not had a chance to take the steps necessary to meet the conditions for release, his detention would breach Article 5.1 of the European Convention during those periods. Article 5.1 allows states to imprison people only when justified by law and requires prisoners not lawfully detained to be released. Since it was not required that the question be resolved in this case, in my judgment I said that I would defer a decision on it until necessary. Lord Mance, who delivers a concurring judgment with whom the remaining justices agree, suggests that James should be interpreted as arising only from a secondary obligation implied by Article 5.1 to progress prisoners through the prison system. Such a breach would not require a prisoner to be released.
Thank you. The court is now adjourned.